Last we left off, we've been talking about the Scopes trial, and we were just about to start discussing with our current legal expert here the breakdown of what happened during the trial and how that got laid out and what some of the ramifications may have been preceding that. But Brad here is an attorney and has been to law school and even has his own law firm. So he is a big shot caller in the legal world. So he should understand a little, at least a little bit of the intricacies. Now, Brad, I got to ask you though, from your analysis of the Scopes trial, how much of this felt like a normal, everyday courtroom scene, and how much of this would absolutely have never flown in a modern courtroom?
So I'm glad you asked that. There were a lot of elements that would be seen in a modern courtroom. For example, there was a courtroom. There was a judge for the most part.
But there
Um,
wasn't even always a courtroom.
yeah, there was a prosecutor. I mean, by name, and a defendant who wanted to be indicted. So about 2%, I would say. It's kind of like 2% milk, in that about 2% of it would be what you would expect out of a courtroom in a court proceeding, and the remainder of it was what I like to call Ken Ham debates evolution with Bill Nye the Science Guy. So anyway,
Who are
but
not
yeah,
scientists are debating science. I understand.
right, and also who are supposed to be in a legal context who it didn't feel like we're doing law, but let's talk about that. Uh, so jumping into sort of the courtroom proceedings and the strategy and just at a big picture view, what was going on here. So we have our main two legal characters here. We have William Jennings Bryan as the prosecutor, and then we have Clarence Darrow as the defense. And
Can we just point out how the defendant is not one of the main legal figures in this trial?
yes. As for the defendant, essentially his horse in the race, as we had discussed earlier, was he was a teacher. He wanted to stand up for the unions. He wanted to argue that this law was harmful to teachers, and also he wanted to get his town more on the map, get some publicity for the town to help with essentially economic purposes.
Just out
And
of
so,
from
go
in
ahead.
your professional opinion, do you
Yes,
believe that there was a financial motivation on the part of Scopes to participate in this trial?
probably. Yeah, most likely.
He actually turned down roles to star in movies afterwards because he was sick of the limelight after that one trial.
Understandable. Um, and for those who don't know, there literally were like street vendors selling monkey-related paraphernalia because this had become the monkey trial and was a nationwide phenomenon. Um, we have our two sides. And on these two sides, Clarence Darrow's full objective, really, at least appeared to be based off of what he was arguing, that he wanted to prove on a national stage that fundamentalist Christianity and all of religion, sort of as a byproduct of that, were anti scientific, anti intellectual, and just essentially bad and didn't have any place in law. On the other side, we had William Jennings Bryan, whose primary objective, based off of the types of things that he put forth in court, seemed to have been to argue that his, I would argue, fundamentalist perspective of Christianity was correct and should be the underpinning of law because it is scientifically true. What's fascinating is neither of those things are legally what the case should have been about if this were going to be conducted like a standard legal trial. Instead, what this case should have been about is A, did the defendant violate the Butler Act, which he confessed to doing, even though he later said he couldn't remember if he actually taught evolution in a class? He confessed he did in court because he wanted to be indicted in the first place. And B, now that we've covered that, because that takes 5 minutes, if that, B, is the Butler Act actually constitutional? Is it an enforceable law? Right? And fascinatingly, the two sides were acting as though they were debating that second point, whether or not the Butler Act was constitutional, and they did touch on it. But most of their debate really wasn't about whether or not the Butler Act was constitutional, except as viewed through, is this true science? And maybe that has some ramification on the constitutionality of the Butler Act, right?
Brad, did that courtroom actually have jurisdiction to rule on the constitutionality of state laws, or is that something that would have had to go into an appellate court in order to rule?
So you can, and I'm not an expert on 1990 or 1920s Tennessee state law, but as a general rule, you can have lower courts essentially the judge say, hey, this isn't constitutional. My highest binding authority is the Constitution, and so I'm going to say not constitutional, go to the next level. And then the next court up is going to slap them around and say, no, it is constitutional, or it's going to uphold it, right? So you can see that. But whatever they say isn't going to have, most likely, unless it just gets picked up as persuasive authority broadly, most likely isn't going to have a broad effect unless this gets appealed and then some higher court says whether or not the thing is constitutional. So really both sides wanted to use this as limelight and to set the stage for subsequent cases at higher courts, specifically the Tennessee Supreme Court, and maybe at the U.S. Supreme Court from there, who knows? But that didn't work out very well. Because if you guys are, is it okay if we move past the trial stage and move to the?
Well, I do have one question on the trial stage.
Yeah.
I'm not sure if it fits in best here, but I guess if we're talking about the trial, from what I understand, Darrow brought in all these expert witnesses from across the country to essentially show that evolution was. It's popularized that he had this idea of trying to show that evolution was true, but from a legal perspective, it sounds like what he really wanted to do was to call into question whether the teaching of evolution actually went against the story of divine creation. Brad, can you read the wording of that section of the Butler Act again for us?
Yes, the Butler Act states that it shall be unlawful to, and skipping ahead, to teach any theory that denies the story of the divine creation of man as taught in the Bible, and to teach instead that man has descended from a lower order of animals.
Okay, so the fact that it says, from what I understand, the legal strategy they were trying to take is the fact that it says "and" means that whatever is being taught needs to meet both of those requirements, that it denies the story of divine creation as taught in the Bible, and that it teaches the rise of humans from lower animals. And so my understanding is that he was trying to bring in these witnesses not just to show reasonability of evolution. What he was trying to bring them in to do, at least in name, was to explain to the jury, who some of them were were actually illiterate and didn't have an education, especially in evolution, trying to explain to them what evolution was. And then he had other expert witnesses who were specifically modernist Christians who were trying to demonstrate that evolution intrinsically is not going against the story of divine creation as taught in the Bible, and therefore teaching evolution in the classroom, as long as you're at least teaching it with the plausibility of theistic evolution, was not breaking the Butler Act. Now, the judge said that that evidence was impermissible because he was trying to keep it from becoming a questioning of the constitutionality of the Butler Act. But I feel like there's a real case to be made there that teaching evolution does not intrinsically go against the Butler Act. What do you think?
I think it's difficult because I see the argument you're making, and I think it does make a lot of sense. I also think, though, that the legislative intent of the Butler Act was pretty clearly to curtail teaching of evolution, and it sort of assumes in the language, I think, that teaching of evolution does inherently deny the story of the divine creation of man. Though that's not necessitated by the language of the act itself. I think the context of the act would lead one to conclude that that was the intent.
And I think that was Judge Ralston's conclusion as well,
Right.
which is why he ruled the way he did on it.
Right, and for that reason, the judge didn't allow basically anything that Darrow was trying to do. Darrow walked in and he said, and his client said, "Yes, I confess to having violated the Butler Act," but essentially not even that. He said, "Yes, I confess to having taught evolution." And then from that point on, every time that Darrow tried to bring forth any kind of expert witness to argue for evolution, the judge said, "No, this isn't about that. I don't particularly care about your experts arguing whether or not evolution is scientifically true. That's not the point of this case," which certainly frustrated Darrow, and I think many of the commentators and viewers around the nation of the spectacle.
Imagine a judge was actually, I mean, he was just like, well, this is about this. This trial is about this particular act. Did he violate it? Yes or no? And he did. Okay, so why are we here? Why are we still having a conversation? Anyway.
What's so funny to me, though, is my understanding is Judge Ralston was one of the people involved in getting this case started. Like, he agreed to hear this case knowing that they were trying to make a spectacle in order to get more tourism in Dayton, and he agreed to it. It's almost like once Brian and Darrow got involved, he was like, I'm in over my head on a legal level, and if I let either of these two run the courtroom, I'm going to lose control. So it feels like he was trying to rein things back in, and he kind of gave up on pumping up the pomp and circumstance of the event so that he could at least maintain some control of the courtroom. That's at least the way I read things.
I think that's largely true. I think, though, he didn't always prevent the pomp and the showmanship, especially when we get
Didn't stop
into
Brian.
right, especially when we get to Brian taking the stand. And I think part of that, and this is just me speculating, is with him, being from Tennessee in the 1920s. I suspect he probably saw things a little bit more Brian's way, and so I
Oh, for sure.
suspect he was on a personal level, and not that this should influence the way he's behaving as a judge, I imagine that he was much more comfortable giving Brian an opportunity to speak and present his views than he might have been giving Darrow the same opportunity.
Yeah, so as I understand what happened here is, Darrow's been saying, I want to bring an expert witness, and Ralston says no. Darrow says, I want to bring this expert witness, and Judge Ralston says no. And so finally, like, they were going to closing arguments, and in fact, a lot of the reporters had left because they had assumed that the majority of the showmanship and fun of the trial was over. And so nobody expected on the final day during closing arguments for Darrow to call one more expert witness to the stand, and this time it was an expert witness on the Bible. And the expert witness he called was Brian. Brian, who had been for now over a year denying even answering through the newspapers Darrow's questions, because he keeps saying that if Darrow's going to ask me questions, then I'm going to ask him questions. But now that they're on trial, Brian is suddenly faced with this choice of either I accept Darrow's challenge and go to the stand and show that I am not afraid to face the evolutionists, or he would have to cower away. And so he accepted the chance to go up on the stand. And even though, like, the other prosecutors kept asking Judge Ralston, please get him down from that stage, Ralston essentially said, no, I'm not going to stop him. Like, it would be doing him a disservice to pull him down now. Which, I don't know if I agree with that, but...
I think
Right. Go ahead,
okay.
Jordan.
I'm just going to interject here because I think there's a certain point to which in the course of the trial, and I don't think that was in closing arguments because as I recall, Darrow specifically said, "I'm not going to give a closing argument."
You're right. So I guess it's closing arguments in name because he declined to give a closing argument. That way Brian wouldn't have a
Exactly.
chance to respond.
Yeah, I found that odd from a legal perspective, but I also, again, don't know Tennessee state law in the 1920s, so I just sort of let it go. Anyway, sorry, Jordan, continue.
No, I think that there was a certain element in which, yes, the judge was very much leaning towards Brian, leaning towards the prosecution in that way, for several reasons. One is obviously, as Brad pointed out, he probably felt more comfortable with his views, but from another perspective, there's a certain element to which, as I'm sitting here thinking about it, you have a guy who is basically like a dog on a chain, and he basically barged into this town, and him and the ACLU basically just like contrived this trial. It basically just were like, we're just going to stage a trial. We're going to go into your town and we're going to prosecute religion.
I mean, they were kind of invited in to make a show.
Yes, but
the idea of Darrow
to a
coming
large
was not
extent, like
expected.
from a legal perspective, from a courtroom perspective, you have somebody who has gone out of their way to contrive a trial. Today, what would that look like if somebody tried to do something of a similar nature? Is this
Maybe
something that goes on a lot, or
maybe like going to a baker and requesting a cake that baker finds offensive, and then taking it to the Supreme Court.
I mean, yeah, and that's
Unconstitutional
I think is
issues, this does
I feel
happen
like
all the time.
from the judge's perspective, there's some element of him going like, you're literally just here to pick a fight. Like, I'm not going to give you a whole lot of grace.
Well, I think also, Jace had hinted to this, asking whether or not that judge could essentially say the law was unconstitutional. A lot of lower court judges would feel that's not their job. And so at a certain extent, even if the judge might have felt that it was unconstitutional, maybe felt it was constitutional, whatever his position was, he might have thought, look, I'm just going to rule on the law as is and let the higher courts deal with this thing, right? So yeah, sorry, continue.
No, I mean, I'm curious to hear your perspective on, if you're in that courtroom and you're witnessing all. I mean, from a legal perspective, or even just from a personal perspective, from a professional perspective in law, how would this trial have shaped up? In if we were to put it in a modern courtroom, what would this look like? Would this go anywhere close to how it went, or would there have been a lot of, would or should the judge have intervened or would the prosecutor, would the defense, would the defense be calling the prosecutor himself to the stand to speak as an
That is
witness? Does
that
that?
is unheard of today, and I think that was unheard of in the 1920s as well. It's difficult to imagine this happening today, but I also think this was extraordinarily out of place for the time. So I don't think it's quite so simple as to say, well, 1920s were weird and things are different today. It's more that this case was very much an outlier both for its time and for today. It's actually fascinating to look at some of the quotes between Darrow and Bryan. Darrow made the accusation, quote, "You insult every man of science and learning in the world because he does not believe in your fool religion." To which Bryan responded, "The reason I am answering," this is the reason he was taking the stand, "is not for the benefit of the superior court." So that is, he's not taking the stand for the purposes of appeal, or for any real legal purpose. Quote, "It is to keep these gentlemen from saying I was afraid to meet them, and let them question me. And I want the Christian world to know that any atheist, agnostic, unbeliever can question me anytime as to my belief in God, and I will answer him." Which is not at all his job, right? Like, this is not a case about Bryan's personal convictions about religion. This is, in theory, a case about whether or not Darrow's client violated the law, right? But by this point, we were neither side seemed overly concerned with that.
So to kind of cheekily, I guess, push back on that a bit. Now, as Christians, is it not our job to be prepared to give a defense for the reason of our hope anywhere at any time to anyone?
Absolutely, yes, and I think he should be prepared. However, I think also there is a certain degree of decorum that is expected both as a Christian and also in a courtroom, two very separate reasons, but very good reasons to conduct oneself well, and to not be contentious. And so I'm not saying that Bryan can't defend himself and that Bryan can't use this stage to forward the cause of Christianity. I think Bryan should have, to the best of his ability, serve the state as though he were serving God and do his job as best he can. Because, for example, whether you eat or drink, do all you do to the glory of God, right? And I think that after the trial, he could have walked up to any reporter with Darrow and said, "Hey, I'm ready for your questioning. Write this down, buddy," and not do it in the courtroom.
Well,
right?
he could have done that. He could have done that.
In the courtroom. Yeah, in the courtroom is a bit of a stretch because they were not in the courtroom. Right before this all happened, the judge said, "Y'all, it's hot in here, and I'm worried that all the heat and all the people in here are going to make the floorboards fall out of our building. So let's go outside onto the stage that was constructed and have this little section of the trial there because, it's so blasted hot." And so they went outside, and that's where Darrow calls Bryan, is on an outdoor stage surrounded by, I think it was 7,000 people or something. I might be exaggerating a bit. I know it was a lot of people. And that's where this part took place, which I think added to kind of the legendary aspect of it, is this is the section that took place outside in front of all these people.
Right. So at that point, this no longer looks like a trial, visually speaking. And I think that plays into Bryan's decision. And I think also, as a fellow Christian, perhaps I would have succumbed to the same temptation in that situation. Because if you're on a literal stage in front of thousands of people and someone's questioning your faith, it's very difficult not to go, "You know what, yeah, I'm going to go on the big stage and I'm going to defend my faith in front of everyone." But that's still not legally or professionally. Sorry, what was that?
I said, I don't know about you. I would never be baited
No,
into an argument.
you can't be baited into an argument you've already started, Jace.
Right. So anyway, let's talk a little bit about what happened after the case, or after at least the trial. So the trial closed by the judge concluding, shockingly, that the defendant, who admitted to having taught evolution in schools, violated the law that said you can't teach evolution in schools, and he gave him the minimum fine of $100, which will become quite a problem.
Didn't the jury find him guilty, not the judge?
I believe that's right, yes, but the judge was the one who
my
gave the fine.
understanding is that for essentially at sentencing or whatever, Darrow comes in and says, "Hey, jury, you're probably going to need to find this guy guilty. In fact, I can't think of any single reason that you wouldn't find him guilty. And the judge had to clarify to the jury, he wants you to find his client guilty, but he's not willing to enter a guilty plea, because if he did, he couldn't appeal this into a further court. And so the jury spent like 5 minutes deliberating is in quotes, because it took, I think, 4 minutes and 30 seconds of that 5 minutes for them to get to the jury box and then say, yeah, he's guilty.
Which makes sense because they weren't inside. So anyway, yes, they find him guilty, and the judge was the one who assigned the fee of $100, which was the minimum under the Butler Act.
Why did the judge get to assign that fee?
He doesn't. He made a mistake, and I'm not sure why he made that mistake, but we will come back to that. So this gets appealed, shockingly, I know, to the Tennessee Supreme Court, because at the time there was no intermediate criminal court between the two in the state of Tennessee. There is now, but there wasn't at the time.
Did Brian take part in the Supreme Court trial?
No, he died, didn't he?
Yeah, Brian died like 3 days after, or no, it was like a week after the Butler and after the Scopes trial. So Brian, this massive defender of the faith. Oh, we have 2 Jordans. Oh, now we have now we have 1 again. Okay, so Brian, this defender of the faith, has just won this trial and stood up to Darrow on a national stage, and people are all taking sides of who's right, who's wrong, and then there's a lot of moderates. But then suddenly, Brian dies of like a heart attack or something from exhaustion, and becomes no longer just this figure who defended faith, but suddenly a martyr for the cause, is the way that it was framed in all the reports.
Say all the reports.
And so now, even those who didn't have a side previously...
Oh my goodness.
I promise we didn't kick him out. But it certainly seemed timed
No
that way.
dissenting here. But yeah, so Brian died and like basically became a martyr for the cause, and at that point, all the kind of festivities were over and everybody chose their sides. It did go on to the Supreme Court. And Brad, what did they say? What was the kind of their ruling there?
Right, so at the Tennessee Supreme Court, and Jordan's back, but at the Tennessee Supreme Court, you have to understand that the Establishment Clause, which is the clause of the First Amendment of the Constitution that was purportedly, that under that clause, this law was unconstitutional. It states, Congress shall make no law respecting an establishment of religion. And so the Tennessee Supreme Court found the law was, in fact, constitutional, and the grounds by which they found that it was constitutional was that this was not inherently a religious issue. That is, some Christians believe in evolution, some Christians don't. Some Jews believe in evolution, some Jews don't. And so if in every major religion there are people on each side of this debate, and if their creeds rarely, if ever, talk about evolution, then this couldn't possibly be a religious issue, and as such, it didn't run afoul of the First Amendment. Now, I find this conclusion hilarious, given, again, the language of the law, which we keep coming back to, that it uses the language, denies the story of the divine creation of man as taught in the Bible. But in any case, the Supreme Court of Tennessee found that this was not a religious issue, and so for that reason it was constitutional. But, despite the fact that they upheld it, they found that because Tennessee judges can't, under the state constitution, assign fines of over $50, that the fine had to be canceled because the judge had assigned it, and it was $100, and the max was $50. Now, $100 is the minimum under the Butler Act, so it should have been given to the jury in the first place as to what the fine would be. But in any case, the ending ruling was that the ruling itself of the lower court was upheld, minus the fine, because that was unconstitutionally performed, and they didn't remand it for a different fine because they said, quote, "We can see nothing to be gained by prolonging the life of this bizarre case," which was one of the wiser things that was said by a legal authority during this entire ordeal.
Red, I'd like to comment on the ruling of the Supreme Court. If I understand correctly, essentially what happened is all of the members of the Supreme Court agreed that the law was constitutional. I thought that as I understand it, the majority of the justices claimed that it was constitutional because the people of the state have the right to choose what is being taught in the public schools. However, one of the judges gave an affirming opinion, but his reason was the one that was actually published, and he was, for some reason, the one that was allowed to write the reasoning behind the ruling. So, if I understand it correctly, the ruling that's published was only really affirmed by one of the justices, and the others all sided with kind of more of Brian's view that the people of the state had the right to choose what was being taught, and not the version that was actually published. Had you read anything on that?
I actually only looked at the published version, so you may be right, but I'm not sure.
Yeah.
In any case, following this case, we had a whole slew of other cases on similar matter, but we won't go into a lot of depth on those, just sort of at a high level. We had Epperson v. Arkansas in 1968 at the U.S. Supreme Court, which ruled that bans on teaching evolution do contravene the Establishment Clause, so this is disagreeing with the case we were just talking about, because their primary purpose is in fact religious. And
Shocking.
this didn't actually matter at all for the Butler Act because it had been repealed the previous year before Epperson v. Arkansas anyway. But after Epperson, we had another case called Edwards v. Aguilard, also at the Supreme Court, and then Kitzmiller v. Dover, which was at a district court in Pennsylvania, but it has been used for persuasive authority all over the country. And essentially, what those two did, just to speak with broad strokes and not go into too much detail, is essentially state that if the primary purpose of a law is to advance a particular religious belief and it lacks a clear legislative purpose, then in that case, no good, unconstitutional, can't do it. And so those cases in combination pretty much killed theistic evolution in schools, for the most part, until pretty recently in history. You see, there was one more case called Lemon v. Kurtzman, which gave us what's called the Lemon test, which says that for Establishment Clause cases, you have to have a secular legislative purpose, have a primary effect that neither enhances nor inhibits religion, and not foster an excessive government entanglement with religion. And that was good law until 2022. But the case that's relevant here is Kennedy v. Bremerton School District, where the court effectively replaced the Lemon test with a new standard that says that government actions involving religion should be evaluated based on whether they align with the original meaning and long-standing traditions at the time of the First Amendment's adoption. Now, if that seems less formulaic than the Lemon test, that's because it is. It's a little bit difficult to determine what exactly that means, and as a result, we've been seeing a lot of cases all over the country on anything Establishment Clause related that are kind of all over the map. For example, we have Texas just recently deciding that every public classroom in the state starting this coming school year has to post the Ten Commandments in the room, as Louisiana also has a law already on this. So those two would very much go against the line of cases we were just talking about with respect to the Butler Act and so on and so forth that seem to say that those types of things would run afoul of the First Amendment. In any case, that's the line of cases that came from this case, from the good old monkey trial. And the monkey business has continued for many years.
Well, speaking of the monkey business that has continued for many years, I think this would be a good spot for us to break before we go into kind of what was the, there was a lot of media associated with this particular trial, and what was said in the trial and how it was portrayed, and how the media has taken that since then, and all the subsequent cases that you just referred to, has left a pretty, I would say, significant mark on our culture. So I think in the next episode we should discuss what the effect of the media was on that trial, and subsequently what that effect had on society and even up to now. So if you want to join us for the next episode, we're going to discuss the media and its influence over the Scopes trial and our culture. Join us on the next one.